Hi guys, welcome back to my channel. So today in this video I would like to read an article entitled The Maritime Executive Carriage of Goods by Sea. There are many ways goods can be shipped by sea. Many exporters who sell abroad regularly will ship their goods in containers. If their volumes are sufficient to fill a container, then the container will contain only their goods. This is a full container load or FCL shipment. If the goods are insufficient or consist of only a small quantity, then the goods are consolidated with other parties. Shippers goods and shipped in a less container load LCL form, whilst the containers themselves are carried by shipping lines with fixed schedules and voyages. Often the shipments are arranged by freight forwarder. The contract of carriage are often bills of lading or seaway bills. The forwarders who issue bill of lading issue house bill of lading. When they book with shipping lines, the shipping lines will issue master bills of lading. Bills of lading. A bill of lading is a document signed by the ship owner or the master or other agents of the ship owner which state that certain specified goods have been shipped in a particular ship, and which purport to set out the terms on which the goods have been delivered to and received by the ship. After signature, it is handed to the shipper, who may either retain it or transfer it to a third person. This person may be named in the bill of lading as the person to whom delivery of the good is to be made on arrival at their destination, in which case he is known as the consignee. If he is not named in the bill of lading, he is usually known as holder or endorser of the bill of lading. The three functions of the bill of lading are as document of title, receipt of the goods, evidence of contract of shipment. Document of title. The bill of lading is a symbol of the goods specified in it. Its possession is equivalent to the possession in the goods themselves, and its transfer, being a symbolical delivery of the goods, has by commercial usage the same effect as an actual delivery in the same circumstances. As regards the ship owner, the bill of lading is a document of title entitling its holder on production to delivery of the goods. Accordingly, a delivery to the holder of the bill of lading discharges the ship owner, provided that it is made in good faith without notice of any defect in the holder's title. The ship owner is not, however, discharged, however bona fide his act may be, by delivery to the wrong person without the production of the bill of lading. By mercantile custom, a bill of lading has become a symbol of the right of property in the goods. Its possession is equivalent to possession of the goods themselves, and its transfer has the same effect as an actual delivery. Presentation of bill of lading. Arising from this function, it has been held that a carrier and his agent who delivers cargo without presentation of the original bill of lading is liable for the value of the goods to the actual goods owner, even if delivery is made to the named consignee. Carriers who release goods without the surrender of the original bill of lading will often obtain an indemnity from the person demanding release to protect against claim from the actual good owner. In the Hai Tong Peng v. Rambler Cycle Code, the Privy Council stated the well-known principle. It is perfectly clear law that a ship owner who delivers without protection of the bill of lading does so at his peril. The contract is to deliver on protection of the bill of lading to the person entitled under the bill of lading. The shipping company did not deliver the goods to any such person. They are therefore liable for breach of contract unless there is some term in the bill of lading protecting them, and they deliver the goods without protection of the bill of lading to a person who was not entitled to receive them. They are therefore liable in conversion unless likewise so protected. Bill of lading as a receipt. Statement about the goods. A bill of lading is an acknowledgement of the receipt of the goods specified in it. This may be qualified by the wording of the bill of lading. Some of the usual qualifying terms found in the front of the bill of lading include ship in apparent good order and condition, weight, quantity unknown, or shipper load and count. The bill of lading and the terms of the contract of carriage. The term of the contract on which the goods are carried are prima facie to be ascertained from the bill of lading. As between the ship owner and an endorsee, the bill of lading constitutes the contract, and it may also constitute the contract as between the ship owner and the shipper. Although the contract of carriage will generally be made before the goods are sent to the ship, the contract may afterwards be reduced into writing and expressed in the bill of lading. Apart from bills of lading, goods can also be shipped by other contracts. An example, contract of affreightment or charter parties. International carriage of goods by sea and contract of carriage are governed to a large extent by international convention. To a large extent, carriage of goods by sea are governed by the International Convention relating to carriage of goods by sea and similar laws enacted in the countries of shipment. The legislation governing carriage of goods at sea sometimes depend on the types of contract that are used in the carriage. Where the seller of the goods sell in the large quantities, it may charge the whole or part of the ship. The charter of a ship is the hire of the ship for the use of the charterer. The three main types of charters are bareboat or demesne charter, time charter, voyage charter, bareboat or demesne charter. Under bareboat demesne charter, the vessel is chartered in pay from the use of charterer for a period of time. The charterer is obligated to supply wherever is needed for the operation of the vessel, including the crew. It has been explained in the Singapore High Court decision of Pan United Shipping Pta Limited v. Cendrawasih Shipping Pta Limited 87 MT 11 2004 SGHC 22 that whether a ship has been demised depends upon whether or not the ship owner has parted with the whole possession and control of the ship and right independent of him and without reference to him to do what he pleases with regard to the captain, the crew, and the management and employment of the ship. So the time is up and the video will be continued on the next part. So don't forget to like, comment, and subscribe. Bye.